Welcome back to the deep dive. Today we're looking at a legal battle that really stretched over decades.
It certainly did.
It pitted one doctor against, well, the whole power of the state, didn't it? And it fundamentally reshaped how we think about freedom in Canada.
Absolutely. It's a story of incredible persistence.
Yeah, this doctor's sheer determination led to this huge Supreme Court decision in 1988, R.V. Morgentaler.
A landmark case, no question.
Now, for many people listening, maybe outside Canada, they might think, oh, that's like Roe v. Wade.
It gets compared a lot.
But the Canadian story, the history, the legal thinking behind it, it's really unique and quite complex, actually, and incredibly powerful when you dig into it.
The reasoning is distinct, definitely.
So our mission in this deep dive, it's not just about the headline, abortion decriminalized. We want to really understand how this relentless legal challenge, and it was a fight fought in courtrooms for years.
A real war of attrition.
Right. How it expanded the constitutional idea of personal security, how it brought this concept of moral autonomy right into the heart of the law.
And how it set a major limit on state control over choices that are just profoundly personal.
Okay, let's unpack this. What are we working with source-wise?
Well, our main sources are from a pretty specialized legal analysis. It's part of a series looking at Commonwealth judicial stories, specifically how constitutional charters, like Canada's, redefine rights in practice.
So focused on the charter impact.
Exactly. And what this material shows isn't just, a political fight. It was deeper, a fundamental philosophical clash, really, between an old criminal law that was Section 251 of the Criminal Code and the new broad protections that came in with the Canadian Charter of Rights and Freedoms.
Got it. Old law versus new rights.
Yeah, and it's important to get the theme straight from the start. This wasn't Morgentaler arguing the state had zero right to regulate healthcare.
Okay, that's a key distinction.
The core issue was whether the state's method of regulation, this specific committee system, was constitutionally fair. Was it just? So the material really digs into how Dr. Henry Morgentaler basically forced the courts to look beyond just the rules on paper.
Right, past the procedure itself.
Yes, and to analyze what true security and liberty actually mean when the state decides to step into a woman's decisions about her own body.
Absolutely. And I think to really get the weight of that final 1988 decision, you have to understand the sheer scale of the fight that came before it.
Decades of struggle.
So Section 1 is really about the man himself, Dr. Henry Morgentaler. He's the protagonist who, you could almost say, invited prosecution just to force this bigger conversation.
He certainly put himself on the line.
So Dr. Morgentaler was a physician in Montreal, and his background is relevant too. He was a Holocaust survivor. And those personal experiences, they really shaped his deep commitment to bodily autonomy, to resisting unjust state control.
You can see how that would inform his perspective.
His big challenge started way back in 1969. Now, before 69, Canadian law was simple. Abortion was basically banned, full stop. Criminal offense.
Very restrictive.
Then that year, the government made a change. They nominally softened the law, but the way they did it, the restrictions they put in place, some argue they were almost worse in practice than the outright ban.
It created a very specific and problematic system.
So Morgentaler's bold move was this. He started performing abortions outside this new legal structure. Why? Because he believed that structure was fundamentally unjust and, frankly, dangerous for women.
He saw the flaws immediately.
Under that revised 1969 Criminal Code, Section 251 still prohibited abortion, unless, and this is the crucial part, unless a special hospital committee called a Therapeutic Abortion Committee, or TAC.
The infamous tax.
Right. Unless this TAC approved the procedure, and the committee had to be in an accredited hospital, and all its members had to unanimously agree that continuing the pregnancy would likely endanger the woman's life or health.
And that term health, well, it was a major point of contention, wasn't it?
Hugely. How was it interpreted?
That's the thing. It was interpreted incredibly narrowly and wildly inconsistently across the country, even across different hospitals in the same city.
So it wasn't a clear medical standard.
Not at all. Morgentaler wasn't just objecting to the idea of having some rules. He was objecting to the cruelty baked into that specific procedure. He saw firsthand how forcing women through this bureaucratic maze—
Demeaning, you imagine.
Absolutely. Demeaning, causing delays.
Yeah.
He knew it created unacceptable suffering, so he defied the law. And, well, the state came down on him hard.
And repeatedly.
Oh, yes. What's fascinating here And central to the whole story is how his repeated challenges just kept the issue burning. It forced this constitutional reckoning.
It wasn't a one-off case.
No way.
Yeah.
The source material lays out this high-stakes, drawn-out legal battle. It went on for almost 20 years.
Yeah.
And the personal cost for Morgentaler was immense.
Let's talk about that legal gauntlet, because that narrative of him being charged, acquitted by a jury, then retried, even imprisoned, that's the engine, right, that drove this whole thing forward.
It's incredibly dramatic, honestly. He was charged over and over, starting in the early 70s.
Right after the law changed.
Yes. But the sequence that really crystallizes his defiance happened in Quebec. He was charged, put on trial, and the jury acquitted him.
The jury heard the evidence and said not guilty.
Exactly. Which was a huge moment of public resistance, really.
Mm-hmm.
The jury heard about the hardships women faced, the barriers, and they essentially refused to apply the law as written. It was like a quiet form of jury nullification.
Wow. So the public, represented by the jury, was sending a message.
A powerful message.
Yeah.
But the legal establishment, they weren't having it.
What happened?
The Quebec Court of Appeal did something pretty extraordinary and controversial. They overturned the jury's acquittal, just set it aside.
Yeah.
And they substituted a conviction.
They convicted him without a jury finding him guilty.
Yes,
Yeah.
which then forced Morgentaler to be sentenced, and he was actually imprisoned. Think about that. His peers said not guilty, effectively questioning the law's legitimacy.
Only for judges higher up to overrule them and put him in jail.
Precisely.
That sequence, the public support from the jury, overruled by the judiciary, leading to the imprisonment of a doctor trying to provide care, that must have just lit a fire under public opinion.
It absolutely did. It put intense pressure on the whole system, political and legal. And Morgentaler's persistence, that was the core of it.
He didn't back down after being jailed.
Not at all. He continued to be charged elsewhere in other provinces. He kept testing the law again and again. Most people would have stopped after that first conviction, that imprisonment.
Understandably.
But his refusal to yield, his willingness to keep providing the service and face the consequences, it meant the issue could never just fade away.
Every charge was another chance to challenge.
Exactly. Every time he was charged, he raised the constitutional argument again. He kept pushing it up the chain, forcing the Supreme Court eventually to confront Section 251 head-on against the brand-new Charter of Rights and Freedoms.
Which had come into effect in 1982.
Right, so the timing became critical.
And his legal strategy, which must have been refined through all these battles, it sounds like it became razor sharp. He wasn't just protesting anymore. He was building a legal case for revolution.
A very focused one.
He zeroed in on two main constitutional arguments. These became the absolute bedrock of the 1988 ruling. First, he argued that Section 251 violated a woman's fundamental right to security of person. Now, that right is found in Section 7 of the Charter. That became the main battleground.
Section 7. Crucial.
And second, he argued that forcing a woman through this incredibly stressful, often demeaning process, or forcing her to carry a pregnancy against her will, that violated her freedom of conscience, also protected by the Charter.
So body and mind, physical integrity and moral freedom.
Exactly. Those two big ideas, physical and psychological well-being, plus the right to make deeply moral choices without the state forcing your hand, that really set the stage for the final showdown at the Supreme Court.
And that takes us right into Section 2, where we really need to get into the weeds of the law itself. Section 251. We need to understand just how dysfunctional it was.
The procedural nightmare, as you called it?
Yeah. The law under fire was Section 251 of the Criminal Code. As we said, it basically banned abortion, but then offered this very narrow criminal law exception through those therapeutic abortion committees, the TACs.
So the starting point was still crime.
Absolutely.
Yeah.
The procedure was treated as a crime first, and only then did they grudgingly offer this really difficult escape hatch.
Okay, let's pause on the tax for a second. Paint a picture for us. If you were a woman needing an abortion back then, what did navigating Section 251 actually look like, feel like? Why were these committees, as you said, the real constitutional villain here?
Well, they were the villain because their structure almost guaranteed failure for many women. The law said you needed at least 3 doctors on this committee. They often met irregularly.
So not always available.
Right. And the problems were sort of twofold. First, the procedural rigidity, and second, this profound inconsistency.
Okay, break that down. Rigidity first.
Okay, rigidity. These committees, by law, had to be in accredited hospitals. Often that meant only larger urban hospitals.
Ah, so access was an issue.
A huge issue. If you lived in a rural area or a smaller town, you might have to travel hundreds of kilometers just to find a hospital that even had a functioning TAC.
Instantly creating inequality.
Massive geographical inequality in accessing what was supposedly a legal exception. In some really large regions of Canada, there were literally 0 committees. For women there, legal abortion was practically impossible, even if it met the criteria.
Wow. Okay, and the inconsistency.
That was maybe even worse. The decision about danger to life or health rested entirely on the subjective judgment of those 3 specific doctors on the committee.
Not an objective medical standard.
No. Often their personal views, their moral beliefs, their religious beliefs could heavily influence their decision, even though the law was supposed to be about medical judgment.
So luck of the draw who was on your committee.
Completely. The source material points this out. Approval rates could swing wildly, like 4% approval in one hospital and 99% approval in another hospital.
Right.
Maybe just down the street.
That's absurd.
It was arbitrary.
Yeah.
And the process itself was inherently demeaning. You had to essentially plead your case, lay bare your personal circumstances to a panel of strangers.
So the system wasn't just restrictive, it sounds like it was arbitrary, deeply unfair, depended heavily on where you lived and pure luck, not actually on medical need.
Exactly. Which sounds like a massive failure of due process, doesn't it?
It really does.
And that was the core of Morgentaler's constitutional challenge. He was arguing that this old criminal law, with this broken mechanism, just couldn't survive when measured against the new rights guaranteed in the Charter.
He was forcing the system to compare a, 19th century criminal approach?
Against 20th century rights protections, specifically Section 7.
Okay, let's pivot to that constitutional cornerstone then. Section 7 of the Canadian Charter of Rights and Freedoms. This is the lever, right? The tool used to dismantle the old law.
It's the absolute key.
So Section 7, it's famous. It protects the right to life, liberty, and security of the person. But before this case, how did courts usually understand security of the person?
Typically, quite literally, physically, protecting you from, say, arbitrary arrest, detention, or police brutality. Physical integrity against state action.
Okay.
Morgenthaler's legal team, though, they aimed for something much bigger. They wanted to profoundly broaden what security of person meant.
How so?
They argued that forcing a woman, under threat of criminal charges, to endure this mandated, arbitrary, often traumatic, and potentially dangerous delay caused by the tax system.
The waiting, the uncertainty.
Yes, that was a direct and devastating violation of her security of person. This forced the courts to acknowledge the huge psychological toll of the law, not just the physical risks.
Bringing mental well-being into the scope of constitutional security?
Precisely. And this is where that idea of the state's procedural burden really comes into focus. The Supreme Court didn't just look at whether the state could legislate on abortion. They looked closely at the method used in Section 251.
The tax system itself.
And they found it deeply flawed. The court explicitly said that the procedural system imposed unjustified psychological and physical burdens on women seeking legal termination.
Unjustified burdens.
Yeah. Think about the psychological load. A woman facing a time-sensitive, incredibly stressful personal and medical decision.
Is then forced into delays while she hunts for a hospital with the committee, waits for them to maybe meet, and then has to endure judgment from doctors who might be morally opposed anyway.
The stress must have been immense.
It sounds like the process itself was almost designed to increase suffering, not alleviate it, which feels like the very definition of disproportionate.
It absolutely failed the constitutional test of proportionality. Here's the idea. If the state wants to regulate something to achieve a goal, maybe protecting fetal interests, maybe ensuring good medical practice, whatever the stated goal.
Right.
But the method it chooses must be proportional to that goal. It can't cause way more harm than necessary.
And the tax system did.
Massively so.
Mm.
The sources detail how the built-in delays often pushed procedures later into pregnancy, into the second trimester.
Which increases medical risks.
Significantly. Both medical risk and psychological distress.
Mm.
So because the law created arbitrary access, huge geographical differences, and mandatory delays that actually increased physical danger and psychological trauma.
The method was just too harmful.
Exactly. It was excessively harmful and burdensome compared to whatever the state's regulatory objective might have been. This lack of basic fairness, of due process, and this lack of proportionality that proved Section 251 couldn't meet the fundamental test of justice guaranteed by Section 7.
Wow. So it wasn't just the ban itself that was unconstitutional, but the very mechanism that was supposed to be the exception to the ban.
That's the critical finding. The exception itself was unconstitutional in its operation.
That sets us up perfectly for Section 3. the moment everything changed. The
Yeah.
Supreme Court judgment in 1988.
The culmination of that long fight.
So after nearly 20 years of Morgentaler pushing, challenging, being imprisoned, finally, in 1988, the Supreme Court of Canada hands down its decision, and it strikes down Section 251 of the Criminal Code completely.
Thank God. Wiped off the books.
And the vote wasn't even close, was it? It was a decisive 5-2 decision.
A clear majority.
This verdict just instantly rewrote the legal landscape for women's health in Canada.
Absolutely transformative. So let's break down the ratio decidendi. That's the core legal reasoning the court used. Why did they strike it down?
Okay.
They used two really powerful interlinked ideas. First, they explicitly confirmed that broader, more holistic view of Section 7 we were just talking about.
Security of the person includes psychological integrity.
Yes. They stated clearly, definitively, that the abortion law violated a woman's right to life, liberty, and security of the person. This confirmed that security wasn't just about physical safety from harm. It included freedom from state-imposed trauma and psychological coercion.
So the court recognized the suffering caused by the system.
They did. They recognized that forcing a woman to carry a pregnancy to term against her will, or subjecting her to the trauma and delays of the tax system, was a clear violation of her Section 7 security.
Okay, that's the first pillar. What was the second?
Equally important, the finding that the state cannot barge into choices this deeply personal without strictly following principles of due process and proportionality.
Which we just established the tax system failed miserably.
Spectacularly, because it operated arbitrarily, unfairly, and caused demonstrable harm, both physical and psychological. It failed both tests.
So if we connect this back to the bigger picture, the ruling essentially said, look, maybe the state has some interest here, but the way it tried to regulate was so fundamentally flawed, so unconstitutional in its operation, that it completely undermined any legitimate purpose it might have had.
That's a perfect synthesis.
Yeah.
The state's goal, even if you grant it legitimacy for argument's sake, cannot be pursued using means that actively violate the constitutional rights of citizens.
The ends don't justify unconstitutional means.
Precisely. The court basically signaled that the individual's constitutional security, their right to be free from state-inflicted harm, including psychological harm, was paramount. And the state's attempt to regulate through Section 251 was just too arbitrary, too damaging, too unfair.
Now, there's often a moral core to rulings like this, something beyond just the legal mechanics. And our sources specifically point to the concurring opinion from Justice Bertha Wilson.
Yes, Justice Wilson's opinion is incredibly important.
Her perspective introduced a concept that really resonated and became a cornerstone of Canadian human rights thinking: moral autonomy.
It added a whole other dimension to the ruling.
She wrote this incredibly powerful concurring judgment. She agreed with the outcome striking down the law, but she pushed the reasoning beyond just the procedural flaws of the tax. She went right into the ethical heart of the matter, the fundamental nature of the choice itself.
What did she say?
She wrote something to the effect of, the decision whether or not to terminate a pregnancy is essentially a moral one, and the state must respect that moral autonomy.
Moral autonomy. That phrase is key.
Tell us why. What's the significance of framing it that way?
Well, using that phrase, moral autonomy, anchors the decision firmly in the realm of personal ethics, individual conscience, self-determination, fundamental human dignity.
Not just a medical procedure.
Exactly. She argued that the state simply isn't equipped, and more importantly, is not constitutionally entitled, to dictate decisions that are so profoundly personal, so tied up with a woman's body, her life path, her own moral framework.
So the state needs to step back from that kind of moral judgment.
Yes. This was really revolutionary in the Canadian legal context at the time. It meant the state couldn't just hide behind the criminal code to enforce one particular moral viewpoint, especially when doing so fundamentally crushed an individual's right to determine their own life and make choices about their own body.
It elevated the individual's decision-making power.
Absolutely. It elevated the personal moral decision-making capacity of the individual above the coercive power of the state when it comes to matters of body and conscience.
It's that philosophical underpinning, isn't it, that gives the ruling such lasting weight. It insists the law has to consider the whole person, mind, body, conscience, not just, say, physical safety in a narrow sense.
Exactly. It demanded a more holistic, humane approach from the law.
But it wasn't unanimous. It was 5-2. The two dissenting judges must have had strong counter-arguments. What was their perspective? Were they concerned about judicial activism? Maybe. Creating rights that weren't explicitly there.
That's a really important point for understanding the legal debate that was happening. Yes, the dissenting judges, with Justice McIntyre writing the main dissent, absolutely argued that the majority was engaging in judicial activism.
What was their reasoning?
Their core argument was that the Charter's guarantees, particularly Section 7's security of the person, were never intended by Parliament to cover this kind of moral or ethical dimension of choice, or the psychological stress caused by a regulatory process.
They saw it more narrowly,
Yep.
physically.
Much more narrowly. Justice McIntyre argued that abortion was fundamentally a clash of competing social values, the value placed on the fetus versus the security and autonomy of the woman.
A balancing act.
Right. And he believed that striking that balance, resolving that complex social conflict, should be the job of Parliament, the elected legislature representing the people, not the job of unelected judges.
Leave it to the politicians.
Essentially, yes. In his view, by expanding security of person to include psychological impacts and procedural fairness in this context, the court was overstepping its bounds. It was reading things into the charter that weren't there, effectively legislating from the bench and creating a new, undefined right to abortion access.
So a classic separation of powers argument.
Very much so. However, the majority explicitly pushed back on that interpretation of Section 7. They argued that the procedural dysfunction of the Tachin system wasn't some abstract policy debate. It was causing real, demonstrable harm that violated existing, recognized constitutional guarantees of due process and security. They weren't creating a new right so much as applying an existing right, Section 7, to a system that clearly violated it.
So the majority felt the legislature had failed to create a constitutional mechanism, forcing the court's hand.
That's the tension, yes. The court stepped in because the existing legislative scheme demonstrably failed the constitutional test.
Okay, that legal back and forth, that tension, it really sets the stage for Section 4. Thinking about the huge impact Morgentaler had both in Canada and maybe even beyond.
The ripple effects were significant.
The immediate impact in Canada is pretty clear. This ruling became the definitive statement on reproductive rights. But interestingly, and this is a key difference from the U.S. situation after Roe v. Wade.
Crucial difference.
The Supreme Court in Canada didn't replace the old criminal law with a new set of regulations or rules about when abortion was allowed. They just struck down Section 251, period.
Leaving a vacuum, essentially.
Yeah.
No federal criminal law governing abortion at all.
And has that stayed the case?
It has. The federal government actually tried a couple of times in the years right after the decision to pass new legislation to introduce some kind of new regulatory framework. But none of those attempts succeeded politically.
So Canada has operated without any federal criminal law on abortion since 1988.
That's right, which makes Canada quite distinct globally. The procedure is now treated and regulated simply as a medical matter, falling under provincial healthcare jurisdiction like any other insured health service.
Managed by provinces, not the criminal code.
Exactly. And as our source material highlights, the significance of this outcome, the complete removal from the criminal sphere, was transformative for reproductive rights thinking, not just in Canada, but it was looked at globally. Well, international human rights bodies, courts in other countries, when they're grappling with state obligations around health, bodily autonomy, physical and mental well-being, they often look to landmark decisions from constitutional democracies like Canada.
For guidance on interpreting broad rights.
Precisely, especially rights like security of the person. The Morgentaler decision provided a powerful precedent for interpreting such rights in a way that includes psychological integrity and procedural fairness.
Which brings us back to that crucial, lasting legal precedent, the expansion of what security of person means. How exactly did the court cement that shift from just physical protection to this more holistic integrity?
They did it by being very concrete. The ruling definitively interpreted security of person under Section 7 to go beyond just freedom from physical harm or restraint. It now explicitly encompassed psychological and moral integrity.
And they showed how the old law violated that.
Yes, by systematically detailing how the specific procedural burdens imposed by the tax system inflicted real psychological trauma. They didn't just state it abstractly.
Can you give an example?
Sure. The court explicitly accepted evidence about the emotional distress caused by those arbitrary approval processes we talked about. The degradation women felt having to plead their case. The intense anxiety, maybe even guilt, produced by mandatory delays that had no medical necessity.
So documenting the mental suffering.
Right. And they concluded, When the state creates a system that subjects an individual to that level of severe, unjustified psychological stress about a fundamental decision concerning their own body, the state has violated their constitutional security under Section 7.
That really raises a big question for us today, doesn't it? When a court decision expands a core right, like security of person, to include psychological integrity, what does that tell us about how the relationship between the state and the individual is evolving in modern law?
I think it suggests a profound maturation, maybe, of constitutional law. It's a signal that modern law can't just operate on a narrow, sort of 19th century view that only cares about direct physical harm.
It has to be broader.
It has to account for emotional and mental well-being, too, especially when state action is involved. The state's procedures, even if they're meant for regulation, can't inflict unnecessary psychological suffering. It basically put a new, higher standard on government processes. They need to be psychologically safe, not just physically safe or procedurally correct on paper.
So it put the state on notice, effectively. Procedural abuse that causes mental trauma is just as unconstitutional as, say, physical abuse or locking someone up without cause.
That's a good way to put it. The means matter. Profoundly.
And if we circle back to that overarching moral statement that kind of ties this whole case together, it's that ultimate lesson the judgment seems to deliver. When the law touches human life, especially in choices this personal, this deep, it has to operate with compassion, not control.
That really captures the shift, doesn't it? The old Section 251 was a perfect model of control.
How so?
Control enforced by the threat of criminal charges. Control enforced through those bureaucratic committees acting as gatekeepers. Control enforced by creating geographical and procedural barriers that made access difficult or impossible.
A system built on obstacles.
Exactly. The Morgentaler decision tore down that model of control, and in its place, it demanded a framework guided by compassion, which, in constitutional terms, translates into respect for the individual's moral autonomy and their full security of person, mind, and body.
That shift really defined a new, more humane standard for how the state should interact with citizens in these deeply personal areas.
A fundamental rebalancing.
Okay, so let's try to quickly summarize this deep dive for everyone listening. It starts with one doctor, Dr. Morgentaler, whose decades-long defiance, enduring jury trials, acquittals overturned, even imprisonment.
That relentless pressure forced the Canadian Supreme Court to finally confront the constitutional validity of the old abortion law, Section 251.
And the court's decision in 1988.
It was fundamentally rooted in the failure of that law's mechanism. The therapeutic abortion committees, the TACTECs, they failed to provide basic procedural fairness, due process, and proportionality.
So striking down Section 251 had a huge effect.
It fundamentally expanded Section 7 rights under the Charter. It confirmed that security of the person includes protection from state-imposed psychological harm and procedural trauma, not just physical harm.
And critically, maybe the longest-lasting legacy, the ruling cemented this principle of moral autonomy in Canadian law.
Affirming that the state cannot dictate these fundamentally personal, ethical choices about one's own body, it set a historic and so far enduring limit on state power over personal bodily decisions in Canada.
Okay, so as we wrap up, we want to leave you with a provocative thought to mull over, building on this case. The ruling found that the state can't intrude on these deeply personal choices in a controlling way. It must respect moral autonomy and govern with compassion.
So the question becomes,
If the law must govern human life with compassion, not control, where else might this principle apply today? Think about new technologies maybe, or evolving social choices that weren't even on the radar back in 1988.
areas like perhaps medically assisted dying, mental health mandates, even how we regulate emerging technologies like AI, which touch on autonomy and potentially carry psychological burdens.
Right. What area of life do you see today that feels like it's currently governed more by control, maybe by overly strict, arbitrary, or trauma-inducing rules and procedures than by compassion?
Where do bureaucratic regulations create more psychological or procedural harm than seems reasonably necessary to achieve a legitimate public goal?
Think about where a reassessment through the lens of moral autonomy and compassion, like the court applied in Morgentaler, might be warranted.
It's a challenging question, connecting that 1988 principle to today's world.
We'll leave that with you to consider.